Now, the City of Johannesburg terminated over 120 job contracts. Mayor Dr. Mpho Phalatse claims the conversion of their employment contracts from fixed term to permanent was irregular. So, can a city council resolution alter employee contracts? Well, to answer this and more questions, I'm joined by Osborne Molatudi, MD of Molatudi Attorneys, and he's also an employment and labour law specialist. A very good afternoon to you. Thank you so much for joining us. I mean, it's an important question as we try and understand the processes that will be followed as 120 people stand to lose their jobs. As you take a look and perhaps listen to some conversations around these contracts, what is your take?
Thank you, and good afternoon, Mpho, and to your viewers. I think one may start to answer this question in a light note, that in a household environment, if someone goes out and marries a spouse, that person 2 years later or even a year later or many years later, he or she is able to change his mind and say, I now want to divorce that spouse. That is doable, that is possible, but unfortunately not within the context of the law, because here we're talking about the same employer that took a decision to convert the fixed-term contracts of certain employees. Now, the same employer can, in terms of the law, can review its own decision. All what needs to happen is that the employer should have applied to a court of law that has the necessary jurisdiction to have that conversion of fixed-term employees into permanent employees set aside, because there's a limit beyond which an organ of state can be allowed to review its own decisions, because at the end of the day, it is the same employer. It's immaterial whether that employer is under the political administration of a particular party, and then a few months down the line or a few years later, another political aide comes in, and then he can then, by a stroke of pen, say, well, that decision was irregular, therefore I'm now correcting him through a resolution. So the nub of my answer is that what should have happened in this instance was to approach a court of law to have all those conversions set aside, or let alone declared null and void.
As matters stand now, the more than 100 employees who stand to lose their jobs have vowed to take this matter to court and fight it because they believe that they're being unfairly treated here. On the other hand, you make mention of the same employer, irrespective of the time frame. But what the other side is saying is that the decision applies to politically aligned officials who don't deliver services to residents, purely tied to a political head. I mean, what sort of leeway is there in that aspect? I mean, you make mention of the process, but in terms of those decisions being made and, a council taking a resolution, how do you see it panning out as they head to court?
What has happened here is that the employer is shifting the burden to those affected employees. So it says, we are going ahead and take the decision. If you are not happy with it, go to court and have it set aside. So that's precisely what they've done. So the affected employees and those who are members of trade unions, you name them, will be perfectly within their right to approach a court of law to have that decision set aside. Because what should have happened, and as I explained earlier on, is the other way around. It is the employer who was expected to approach a court of law to have those conversions set aside, because it's the same employer that took a decision to convert them. Whether they are politically aligned or not, those will be some of the reasons that they can put forward in a court of law. Because you must remember, to a third party and to the affected employees, everything may have been done perfectly within the law. I mean, if the job is advertised to say we are now going to convert fixed-term contracts into permanent, and then they apply, there's interviews, there's regularization by a human resources and legal department. Who is anyone to now step in and say, no, I'm not happy with that decision, therefore I'm going to change it? That's not how it works in terms of employment law and, of course, administrative law. You can't review and set aside your own administrative action. You have to approach a court of law. The only exception is if you do so with the agreement of the affected employees, which is called by a mutual agreement, and you have to do so promptly to say, hey, Mpho, you were irregularly appointed to be a presenter on Newzroom Afrika. We need to set this aside because you are supposed to be A, B, C, and D. If you agree, end of story. But if you do not agree, the employer cannot then shift that burden to you and say, no, we are going to, in any event, remove you. Therefore, if you're not happy with that decision, do so. Remember, we're talking an organ of state.
Absolutely.
So in my view, what the City of Johannesburg should have done is to approach a court of law. But unfortunately, it's the other way around. Now the affected employees who may not have enough resources, and unless if they belong to a union, they now have to run to court to have that resolution set aside.
Thank you so much. We're going to have to leave it there for now. Thank you for your time and input there. Osborne Molatudi, MD of Molatudi Attorneys, speaking, of course, when it comes to the more than 100 employees of the City of Johannesburg who are facing the chop. They stand to lose their jobs, just weighing in on